We back at chapter 4 of mortgages of immovable property and charges. 58. Oh, excuse me. 58 mortgages, mortgagor, mortgagee, mortgage money, and mortgage deed defined. 8. A mortgage is the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan and existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. The transfer is called a mortgagor. The transferor is called a mortgagor. The transferee is a mortgagee. The principal, money, and interest of which payment is secured for the time being are called the mortgage money, and the instrument, if any, by which the transfer is effected is called a mortgage deed. B. Simple mortgage. Simple mortgage, where without delivering possession of the mortgage property, the mortgagor binds himself personally to pay the mortgage money and agrees expressly or impliedly that in the event of his failing to pay according to his contract, the mortgagee shall have a right to cause the mortgaged property to be sold and the proceeds of sale to be applied so far as may be necessary in payment of the mortgage money. The transaction is called a simple mortgage, and the mortgagee a simple mortgagee. C. Mortgage by conditional sale, where the mortgagor ostensibly sells the mortgage property on condition that on default of payment of the mortgage money on a certain date, the sale shall become absolute, or on condition that on such payment being made, the sale shall become void, or on condition that on which payment being made, the buyer shall transfer the property to the seller. The transaction is called the mortgage by conditional sale, and the mortgagee a mortgagee by conditional sale, provided that no such transaction shall be deemed to be a mortgage unless the condition is embodied in the document which effects the purports to affect the sale. D. Usufructory mortgage, where the mortgagor delivers possession, or expressly or by implication binds himself to deliver possession of the mortgage property to the mortgagee and authorizes him to retain such possession until payment of the mortgage money and to receive the rent and profits accruing from the property or any part of such rents and profits, and to appropriate the same in lieu of interest or in payment of the mortgage money, or partly in lieu of interest or partly in payment of the mortgage money. The transaction is called a usufructory mortgage, and the mortgagee a usufructory mortgagee. E. English mortgage, where the mortgagor binds himself to repay the mortgage money on a certain date and transfer the mortgage property absolutely to the mortgagee, but subject to the proviso that he will retransfer it to the mortgagor upon payment of the mortgage money as agreed. The transaction is called and English mortgage. Mortgage by deposit of title deeds, where a person in any of the following towns, namely the town of Calcutta, Madrid, and Bombay, and in any other town which the state government concerned may, by notification in the official gazette, specify in this behalf, delivers to the creditor or his agent documents of title to immovable property with intent to create a security thereon. The transaction is called a mortgage by deposit of title deeds. G. Anomalous mortgage, a mortgage which is not a simple mortgage, a mortgage by conditional sale and usufructory mortgage, an English mortgage, or a mortgage by deposit of title deeds within the meaning of this section is called an anonymous mortgage. 59, mortgage when to be by assurance. Where the principal money secured is 100 rupees and upwards, a mortgage other than the mortgage by deposit of title deeds can be effected only by the registered instrument signed by the mortgagor or and attested by at least 2 witnesses. Where the principal money secured in less than 100 rupees, the mortgage may be effected either by a registered instrument signed and attested as aforesaid, or except in the case of a simple mortgage by delivery of the property. 59A. References to mortgagors and mortgagees to include persons deriving title from them, unless otherwise expressly provided. References in this chapter to mortgagors and mortgagees shall be deemed to include references to persons deriving title from them, respectively. Rights and liabilities of mortgagor. 60. Right of mortgagor to redeem. At any time after the principal money has become due, the mortgagor has a right on payment or tender at a proper time and place of the mortgage money to require the mortgagee to deliver to the mortgagor or the mortgage deed and all documents relating to the mortgage property which are in possession or power of the mortgagee. B. Where the mortgagee is in possession of the mortgage property, to deliver possession thereof to the mortgagor. And C. At the cost of the mortgagor, either to retransfer the mortgage property to him or to such third person as he may direct, or to execute, and where the mortgage has been effected by the registered instrument, to have registered an acknowledgement in writing that any right in derogation of his interest transferred to the mortgagee has been exalted, provided that the right conferred by this section has not been exalted by act of the parties or by decree of a court. The right conferred by this section is called a right to redeem, and a suit to enforce it is called a suit for redemption. Nothing in this section shall be deemed to render invalid any provision to the effect that if the time fixed for payment of the principal money has been allowed to pass, or no such time has been fixed, the mortgagee shall be entitled to reasonable notice before payment or tender of such money. Redemption of portion of mortgage property. Nothing in this section shall entitle a person interested in a share only of a mortgage property to redeem his own share only, on payment of the proportionate part of the amount remaining due on the mortgage, except only where a mortgagee, or if there are more mortgagees than one, all such mortgagees has or have acquired in whole or in part the share of the mortgagor. 60A. Obligation of transfer to third person instead of retransference to mortgagor. 1. Where the mortgagor is entitled to redemption, then on the fulfillment of any conditions on the fulfillment of which he would be entitled to require the retransfer, he may require the mortgagee, instead of the retransferring the property, to assign the mortgage debt and transfer the mortgage property to such third person as the mortgagor may direct, and the mortgagee shall be bound to assign and transfer accordingly. 2. The rights conferred by this section belong to and may be enforced by the mortgagor or by an encumbrancer, notwithstanding an intermediate encumbrance, but the requisition of any encumbrancer shall prevail over the requisition of the mortgagor, and B. Between encumbrancers, the requisition of a prior encumbrancer shall prevail over that of a subsequent encumbrancer. 3. The provisions of this section do not apply in the case of a mortgagee who is or has been in possession. 60B. Right to inspection and production of documents. A mortgagor, as long as his right of redemption subsists, shall be entitled at all reasonable times, at his request and at his own cost, and on payment of the mortgagee's costs and expenses on this behalf, to inspect and make copies or abstracts of or extracts from documents of title related to the mortgage property which are in the custody or power of the mortgagee. 61. Right to redeem separately or simultaneously. A mortgagor who has executed 2 or more mortgages in favor of the same mortgagee shall, in the absence of a contract to the contrary, when the principal money of any 2 or more of the mortgages has become due, be entitled to redeem any one such mortgage separately, or any 2 or more of such mortgages together. 62. Right of usufructuary mortgagor to recover possession. In the case of a 62. Right of usufructuary mortgagor to recover possession. In the case of a usufructuary mortgage, the mortgagor has a right to recover possession of the property together with the mortgage deed and all documents relating to the mortgage property which are in possession or power of the mortgagee. A. Where the mortgagee is authorized to pay himself the mortgage money from the rents and profits of the property when such money is paid. B. Where the mortgagee is authorized to pay himself from such rents and profits or any part thereof, a part only of the mortgage money, when the term, if any, prescribed for the payment of the mortgage money has expired, and the mortgagor pays or tenders to the mortgagee the mortgage money or the balance thereof, or deposits it in court as hereinafter provided. 63. Assertion to mortgage property. Where mortgage property in possession of the mortgagee has, during the continuance of the mortgage, received any accession the mortgagor upon redemption shall, in the absence of a contract to the contrary, be entitled as against the mortgagee to such accession. The accession required in virtue of transferred ownership, where such accession has been acquired at the expense of the mortgagee and is capable of separate possession or enjoyment without detriment to the principal property, the mortgagor desiring to take the accession must pay to the mortgagee the expense of acquiring it. If such separate possession or enjoyment is not possible, the accession must be delivered with the property, the mortgagor being liable in the case of an acquisition necessary to preserve the property from destruction, forfeiture, or sale, or made with his assent, to pay the proper cost thereof as an addition to the principal money with interest at the same rate as is payable on the principal, or where no such rate is fixed, at the rate of 9% per annum. In the case last mentioned, the profits, if any, arising from the accession shall be credited to the mortgagor. Where the mortgage is usufructory and the accession has been acquired at the expense of the mortgagee, the profits, if any, arising from the accession shall, in the absence of the contract to the contrary, be set off against interest, if any, payable on the money so expended. 63A, improvements to mortgage property. Where mortgage property in possession of the mortgagee has, during the continuance of the mortgage, been improved, the mortgagor upon redemption shall, in the absence of a contract to the contrary, be entitled to the improvement, and the mortgagor shall not, save only in cases provided for in subsection 2, be liable to pay the cost thereof. 2. Where any such improvement was effected at the cost of the mortgagee and was necessary to preserve the property from destruction or deterioration, or was necessary to prevent the security from becoming insufficient, or was made in compliance with the lawful order of any public servant or public authority, the mortgagor shall, in the absence of a contract to the contrary, be liable to pay the proper cost thereof as an addition to the principal money with interest at the same rate as is payable on the principal, or where no such rate is fixed, at the rate of 9% per annum, and the profits, if any, accruing by reason of the improvement shall be credited to the mortgagor. 64. Renewal of mortgage lease. Where the mortgage property is a lease and the mortgagee obtains a renewal of the lease, the mortgagor upon redemption shall, in the absence of the contract by him to the contrary, have the benefit of the new lease. 65. Implied contracts by mortgagor. In the absence of a contract to the contrary, the mortgagor shall be deemed to contract with the mortgagee. A. That the interest which the mortgagor possesses to transfer to the mortgagee subsists, and that the mortgagor has power to transfer the same. B. that the mortgagor will defend, or if the mortgagee be in possession of the mortgage property, enable him to defend or mortgagor's title thereto. C. That the mortgagor will, so long as the mortgagee is not in possession of the mortgage property, pay all public charges accruing due in respect of the property. D. And where the mortgage property is a lease, that the rent payable under the lease and the conditions contained therein and the contracts binding on the leasee have been paid, performed, or observed down to the commencement of the mortgage, and that the mortgagor will, so long as the security exists and the mortgagee is not in possession of the mortgage property, pay the rent reserved by the lease, or if the lease be renewed, the renewed lease perform the conditions contained therein and observe the contracts binding on the leasee, and indemnify the mortgagee against all claims sustained by reason of the non-payment of the said rent, or the non-performance or a non-performance or non-observance of the said conditions and contracts. E. And where the mortgage is a second or subsequent encumbrance on the property, that the mortgagor will pay the interest from time to time accruing due on each prior encumbrance as and when it becomes due, and will at the proper time discharge the principal money due on such prior encumbrance. The benefit of the contracts mentioned in this section shall be annexed to and shall go with the interest of the mortgagee as such, and may be enforced by every person in whom that interest is for the whole or any part thereof from time to time vested. 65A. Mortgagor's power to lease. 1. Subject to the provisions of subsection 2, the mortgagor, while lawfully in possession of the mortgage property, shall have power to make leases thereof which shall be binding on the mortgagee. 2A. Every such lease shall be such as would be made in the ordinary course of management of the property concerned, and in accordance with any local law, custom, or usage. B. Every such lease shall reserve the best rent that can reasonably be obtained, and no premium shall be paid or promised, and no rent shall be payable in advance. C. No such lease shall contain a covenant for renewal. D. Every such lease shall take effect from a date not later than 6 months from the date on which it is made. E. In the case of a lease of buildings, whether leased it or without the land on which they stand, the duration on the lease shall in no case exceed 3 years, and the lease shall contain a covenant for payment of the rent and a condition of re-entry on the rent not being paid within a time therein specified. 3. The provisions of subsection 1 apply only if and as so far as a contrary intention is not expressed in the mortgage deed, and the provisions of subsection 2 may be varied or extended by the mortgage deed, and as so varied and extended shall, as far as may be, operate in like manner and with all like incidents, effects, and consequences, as if such variations and extensions were contained in that subsection. 66. Waste by mortgagor in possession. A mortgagor in possession of the mortgage property is not liable to the mortgagee for allowing the property to deteriorate, but he must not commit any act which is destructive or permanently injurious thereto, if the security is insufficient or will be rendered insufficient by such act. Explanation: a security is insufficient within the means of this section unless the value of the mortgage property exceeds by 1/3, or if consisting of buildings exceeds by 1/2 the amount for the time being due on the mortgage. Rights and liabilities of mortgagee. Rights and liabilities of mortgagee whenever we get back.